An election must manifest the will of the people, freely made and on an informed basis. If that proposition is accepted, it follows therefore that for an elections to be free and fair, voters must be able to make independent choices without being coerced into options, and that their choice is informed. Informed because they would have had the benefit of listening to all differing policy propositions. The Code of Conduct, therefore, is a contribution aimed at promoting conditions that are conducive to free and fair elections. It does this principally by doing two things. One, putting in mechanisms to foster tolerance of democratic political activity. Secondly, by cultivating an environment within which free political campaign and open, public and robust debate can take place. To leaders of parties, members of political parties, candidates, the code has the force of law. In other words, it creates crimes out of certain prohibited conduct. It makes certain prohibited conduct offenses. So what is an offense, or what is a statutory offense? A statutory offense is a crime that is created by statute or by law. It may coexist with common law crimes, it may not, but it is a specific crime created in terms of statute. It could be severe, it could even be less severe, but it's still an offense nonetheless. For conduct or an omission to qualify as a statutory offense or an offense, there must at least be three elements. The first is that there must be commission and not the Electoral Commission. Commission meaning an act, or there must be omission or failure to act. An example of an act or a commission is a person who defaces or removes a poster of an opposing political party or candidate. Failure to act or omission could be failure to heed an instruction of a presiding officer at a voting station or to follow lawful instructions of the commission. The second element of an offense is that the act or failure to act must be unlawful. It is in the statute. You don't act consistent with the statute, you are liable for committing an electoral offense. And the last element is that there must be fault or a guilty mind, i.e. you know that removing a poster of a party is unlawful, you persist with that behavior nonetheless. Now it begs the question, who is bound by the code? The code applies to political parties. It applies to candidates, both independent or those nominated by political parties. It goes beyond that. It also applies to members, party agents, and supporters of the party. And in order to ensure adherence, if a candidate of a party is found guilty for behavior inimical to the code, it is regarded as if the party itself is also guilty of that behavior. This is so because the code requires purposeful proactive action on the part of political parties to counsel their members, their candidates, their supporters, their agents to conduct themselves in a manner in keeping with the electoral code. The code is time-bound. It doesn't apply for all time. And this is key because by its nature it has the possibility and potential to limit certain guaranteed rights. So the purpose is that rights should be limited for a specific purpose and for as short a period as is possible. To that end, the code only applies from the date on which an election is called until the date on which the result of an election are declared. However, if a party or candidate behaves in a manner that offends the code outside of that period, that party or candidate can still be taken to task using other laws or even common law crimes. It doesn't mean it makes it less of a offense at those moments. The scheme understands that electoral offences must by their nature be dealt with speedily before an election is concluded. Therefore, there is a speedy avenue to justice. In other words, an electoral court is created to deal specifically with offences to the code. The electoral court can, in terms of its rules, designate other courts to also have jurisdiction so that access is meaningful, but redress it is also real in that you can take decisions while an election is still ongoing. The electoral court has far-reaching powers, and all of us here should stay away from conduct that will result in a conviction, because on conviction, the electoral court could impose a combination of sanctions. Among those are the following, in no particular order. The court can impose a fine, a monetary fine. 2, it can order that a party forfeits its election deposit. You will recall that a party pays a deposit, and if a party gets a seat or wins a seat, it gets the deposit refunded in total. So if a party is found guilty, the court could order that the party forfeits their deposit. The court could also direct that the party is barred from using public media for purposes of campaign. It could be barred from putting up posters and campaigns and distributing campaign materials, or it could even be stopped from campaigning in a certain area. If the conduct of the party that the court frowns on is territorially based, the court could also deduct the result, the votes for a party in a specific station, in a specific geographic area, in a province, or in very extreme cases, the court may order the deregistration of a political party. Deregistration has very significant implications, because if a party doesn't exist, it follows that the seats that it had won, it can't keep, because for you to keep a seat, you must be a registered lawful entity. The court could also order a disqualification of candidates, and this one we have a recent example in the 2016 general election. A court ordered the disqualification of a candidate and the removal from a list of a political party. From the foregoing, it is clear that sanctions are within the remit and province of the electoral court. The Electoral Commission cannot impose sanctions. At best, what the Commission can do is to investigate, and based on its investigation, form a view. And once it is formed a view, make an assessment whether that view is supported, corroborated by evidence. And if there is sufficient evidence, the Commission may then make an application to the Electoral Court. And if the Electoral Court finds that the Commission has made out a case, that court can mete out those sanctions. The sanctions of the Electoral Court are civil in nature, but there's nothing that stops criminal prosecution in parallel to civil litigation. And this I'm saying to my colleagues in political parties. If you have formed a view that there is behavior that is contrary to the Electoral Code or prohibited conduct, you have direct access to the court. You don't have to go necessarily via the Electoral Commission. You can, on your own, go to court, adduce the necessary evidence and ask the court to mete out the sanctions that are in law. And because that court exists only for elections, even though it has the standard of a high court, it has its own rules which are more flexible, less rigid than the rules of the court, and therefore all that you need to do to go to that court. You don't even need legal representation. You just need to write out your case clearly in an affidavit form and also submit a notice of motion. A notice of motion is a court paper that says, this is what I want the court to order. You submit that. The court normally hears matters within 3 days on an expedited basis, because it understands that matters must be resolved before any election is over. What are examples of the things in the code? If you are a father like me and support Arsenal, and because Arsenal lost or is in the habit of losing, you then take it out on your kids and say, in this household, everybody is going to support the party that I support. Vote for the party of my choice. Or I am withdrawing support to you. I am opening myself to be guilty of prohibited conduct in the form of undue influence. So as head of households, be careful how you exercise that power, because you might find yourself in front of the court. Defacing of posters doesn't need an explanation. It is both civil and it could also attract criminal sanctions. The severity of electoral offences are such that if a person is found guilty of those things, the court may impose a fine or a custodial sentence of not more than 10 years. So if you go to the schedule of crimes and look at what 10 years attracts, it means the court looks dimly on those types of offences. In summary and in conclusion, the code introduces certain crimes. Those crimes are time-bound from the day on which an election is called to the day on which the result of an election are made known. The code binds both the party, whether a party signs the code today or doesn't sign, it is bound. At the point when you apply to register a party, you also warrant that you are bound by the code of conduct. At the point when you submit your list of candidates, you become bound again. So the provision extends to also independent candidates. While the Commission may investigate prohibited conduct, it may not impose sanctions. Sanctions are within the remit and province of the electoral court. And once the court finds that the person is guilty of that, they may impose the harsh sentences that I have indicated. In closing, parties are allowed to have temporary operating facilities outside voting stations, provided that those structures do not impede direct access of voters into a voting station. If you operate those structures in a way that interferes with voters, or a voter forms a view that or a voter develops a reasonable apprehension that if they go close to a voting station, they may be harmed. That voter is able to go to the electoral court, and we have sufficient court jurisprudence. In Babazan, the court set aside a by-election because there was violence outside voting stations. In Umdoni, not Umdoni, after the 2021 general elections in a ward in Inok Mkijima, I think, in the Eastern Cape. The candidate that lost that ward went to court, said at about 7:45 at night, there were people with party regalia burning tires in the vicinity of a voting station. As a result, people who were going to vote for me turned back, they attached affidavits. As a result, the outcome of the election in that station could not have been free and fair. The court ordered that a by-election be rerun, and it set aside the result that the commission had declared for that stations. Let us take heed of this and counsel those who are going to run our campaigns, those who are going to be our mobilizers and agents on the ground, to behave in a manner that is consistent with the code. There are 27.7 million registered voters in the country, so there are enough voters for all of the political parties represented here. I wish you well in your campaigns, and may all the parties win. Thank you very much.
Another round of applause for the Deputy